in Atlanta with what you see right here. Another big hearing in that Trump RICO case. The judge making news with one of the first setbacks for prosecutors in D.A. Willis's office. You may recall the DA had been pushing for one big joint RICO trial on a fast track for October. Today, the judge rejected that joint trial request, ruling that the first trial for two Trump lawyers will begin October 23rd, but not for any of the other co-defendants. Now, this was somewhat expected by legal experts. Here's what prosecutors had argued about doing and hoping that they could get this all into one trial.
We contend that we must prove the entire conspiracy against each and every one charged. Each and every one charged.
Anytime a person enters into a conspiracy, they are liable for all of the acts of all of their co-conspirators. And that's it. Evidence against one is evidence against all.
Evidence against all, and they were hoping to try them all and soon. That is now a no-go. Only these two defendants who pushed for a speedy trial will be part of the first one. That's Ken Chesebro and Sidney Powell. In October, Trump and other RICO defendants get more time because the judge has now ordered what is called a severance. And this new ruling says, quote, severance is an absolute necessity in this case. Indeed, it's so wide, they note that there isn't even a local courtroom adequately large enough to hold all 19 defendants and their teams. Now, what does this RICO trial ruling mean for the remaining defendants? Well, we don't really know. The judge today basically says stay tuned, noting that divisions of these 17 defendants may well be required, meaning further divisions, but, quote, that is a decision for another day. To paraphrase the Bermudan singer Collie Buddz, tomorrow's another day, so I just want you to be prepared because judgment come. Kind of applicable, if you ask me. Now, beyond that particular ruling, there were some other key moments in the courtroom. A clash where a RICO defendant's lawyer claims prosecutors were outright lying as they debated this issue about talking to the grand jurors.
There is no authority that allows what they're asking the court to allow them to do.
The Collin case says we can talk to grand jurors. So the fact that she got up here and lied to the court.
All right, Mr. Graham, I don't think we need to go down that road.
Your Honor, she lied to the court, and I apologize, and she defamed my co-counsel.
I've said it's over.
All right.
You could hear in the background there, the judge basically saying you don't need to go down that road and that level of clash is over. And that's a reminder in advocacy. There's things you can say that are going to work perhaps for making your client happy or for getting the public riled up or even getting headlines. We did play this on the news if that was your goal to get on the news. But let's be clear, when the judge is saying enough, stop, don't go down that road, you are alienating the most important person in the room who actually is going to decide whether you win or lose on any one of these issues. The judge also ruled in a way that could help some of these defendants, and I want to share that with you here. The interesting finding that they're going to go down the road of allowing the lawyers to speak to, on some issues, the grand jury witnesses.
You have a right to talk to grand jury witnesses. What about? We'll get to. And I'll say it on the front end because these grand jurors have been through a lot.
Yes.
And I think we need to recognize that and craft a remedy here that recognizes that.
You may recognize the judicial or lawyerly language there. It could almost sound like anything. It sounds very diplomatic, but let's be clear about, among other things, what the judge knows. There are safety concerns. The FBI has already had to open investigation into violent threats against law enforcement and the process there in the context of what Donald Trump has openly, publicly said and done and posted about in multiple jurisdictions. As for the evidence in the complex caseload, the RICO defendants' lawyers argue that they are also getting overwhelmed by the evidence they're receiving. And this was another moment we saw here, how this is going to go, and we get to see it all in real time. That's what makes Georgia such an interesting legal place to cover. We'll show you exactly what happened as prosecutors bluntly pushed back today, suggesting this evidence is available, and it is not their job to spoon-feed lawyers for RICO defendants.
It appears as though Mr. Rafferty wants us not only to provide the information to him, but to spoon-feed it to him.
You do not satisfy your Brady obligations by turning over 8 terabytes worth of material and say, go find it.
We're spinning our wheels at this point. There's a lot that needs to be done between now and October 23rd, and I think the best use of our time isn't being in court here talking at each other.
Like I said, if the judge is tired of the lawyers talking, well, some of the lawyers probably aren't doing the best on their issues, although, again, everyone has the right to go through all this today. We have two legal experts standing by that are going to explain to us exactly what we just saw and why it matters. But before I get to them, there is one more thing, and it is one of the most tantalizing rulings about something that we do not know. The world, of course, has now seen the faces of these 19 Georgia RICO defendants. And we also got that new release of the investigative grand jury report just last week, which revealed other people that the original investigative grand jurors thought should have been indicted. Some of them were not. If you follow the news, that was widely discussed. But today, for the first time, prosecutors are saying they will hand over to defense lawyers new information, the actual names of 30 people. That's a lot. 30 people who the DA has deemed secret, unindicted co-conspirators in this RICO coup. Now, that will be a key part of what happens from here, because we know that the state's roadmap and theory of the case includes both those who were indicted and those who it says are unindicted but somehow involved. Now, this does not mean we will all immediately learn who those people are. The idea, the legal idea and the fairness is that the defense will get this info, and that's part of how they get to make the best defense possible. Some of this may become sort of inferred or basically known at trial. Some may not. The DA is basically requesting an order to keep these names secret from everyone else. So they are for the lawyer's preparation, not for the leaking or posting on Truth Social or anything like that. If you take it all together tonight, you might say, okay, Ari, what did we really learn if some of it's secret and some of it is for later? And I'll tell you what we're learning. We are learning the schedule, the evidence, the battle lines, the boundaries of what will ultimately come. In other words, how the rules are set and what's in and out of bounds will give a lot of shape to what happens at these trials, and whether the defense lawyers get anywhere with some of what they want to poke holes, or whether the prosecutors can keep up the speed and the larger RICO strategy they have. And that ultimately matters for the reason that everyone's following this case. It is not about the random bail bondsman or the random lawyer, even though those people will get their day in court. It is about whether the ex-president, who's now running for office, will ultimately be found guilty of trying to steal the election in this state or not. And we are well on our way to seeing what that case looks like as we head towards a highly anticipated televised trial of the former president, Donald Trump, and his RICO co-defendants.
Well, it was interesting that the judge, I think, really kept control of that courtroom as things started to get pretty heated. You know, very similar to Judge Chutkan when she said, let's take the temperature down to John Lauro. Very similar kind of control of the courtroom. Some interesting issues. I think, you know, defense has some valid arguments in terms of getting dumps of documents and not having a roadmap. You don't have to spoon feed defense necessarily, but if you're dumping a lot of documents, it is helpful to have a log or at least be able to point defense counsel to certain evidence that may be exculpatory or helpful to the defense. So I think there are some arguments there that were valid, that were raised today.
Yeah, and David, curious your highlights as well as what it means on the rubber hits the road on some of those interviews that the defense lawyers want to do. And I'll tell you and viewers, we've got this up here where this is some of those key moments from today. Get ready for televised trials. I mean, the October one is now scheduled.
I think it's great it's televised, but and unfortunately, you see kind of the bad side of it in the earlier segment with some of the theatrics. It encourages some of the theatrics. But I think with regard to the witness, it's going to be interesting to see what the judge actually permits. I think it's probably going to be much more limited than one would expect from these lawyers' arguments as to what he's going to permit. I think it's probably going to be limited mostly to process, to whether or not there's an intimidation, whether or not the process was followed properly, and so forth. So, you know, we'll have to see what the judge rules on this.
Christy, if you are a defense lawyer, why do you want to know the names of those other unindicted folks?
You want to know, maybe they have evidence that's helpful to your defense. Maybe they have something that's exculpatory that you want to explore. Maybe they have similar kinds of evidence against them, but they weren't charged, and you want to claim that there's some kind of selective prosecution. Any number of reasons why you'd be curious about who those people are and how they could potentially be helpful to your case.
Yeah. David, we've got a lot of lawyers piling up. We've got indicted lawyers, they get their own lawyers, et cetera. I'm curious what you thought of some of the lawyering, because it felt, and I say this respectfully, I think people who watch the show know that we try to get everybody on. We had Matt Gaetz on last night. But I have to say, as an objective matter, some of the lawyering felt Trumpy, to me, by which I mean intended for something other than the judge and legal advocacy. I'll play you briefly Cheesebro's lawyer kind of going off.
What if a grand juror felt, and I'm not saying this is true, but what if a grand juror felt that they were bullied by the state into prosecuting? What if a grand juror felt that the state, went a little overboard?
It's the same attorney who seemed to lose the judge at a point when he sort of wantonly accused folks of lying. Your thoughts?
I think the challenge for these lawyers here in a case, a very high-profile case, is who is the audience is most important. And so they have a client who thinks that the audience is the public, but the lawyers have to recognize that first and foremost, you got the judge, you're going to have the jury, and I think the bickering between him and his adversaries also is not productive. Calling him a liar, particularly this early on, that's not really going to work out too well going forward. They're going to want some things from the prosecutors later on, and trying to develop a good relationship instead of these type of theatrics is probably more strategic than what we saw here.